Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. This is a TD Jakes versus Dwayne Youngblood update. Last we spoke on this, TD Jakes, Pastor or Bishop TD Jakes, I should say, filed a lawsuit in Pennsylvania against Dwayne Youngblood, and I pretty much go back to that video if have not um, you have not reviewed that case and tuned onto that. But Dwayne Youngblood is a two-time convicted felon who is also a registered actual offender or ex-offender. Um, and he has put forth some allegations against Bishop T.D. Jakes. And this filing or this lawsuit came about a day after Bishop was rushed to the hospital on a Sunday during service. And so they put the narrative out that, from all the stress and the accusations and everything that Dwayne Youngblood has already put out in the universe, that took a toll on Bishop T.D. Jakes, and he had to make some moves. So, as of recently, a couple of days ago on the 17th, Bishop T.D. Jakes has, or his attorney has filed a motion to expedite discovery. And discovery is a phase where the parties exchange information and documents voluntarily. If they don't, then what happens is counsel will subpoena certain records or information or witnesses to have the information, documents, or witnesses at a certain date and time. uh, the motion to expedite it is just meaning that they are wanting to get this information and documents sooner than the usual deadline for discovery. That means that it could be for a number of things. It could be that they are trying to ensure that they get all of the information or all of the documents, or that it is a urgent matter in the case that they need to get this case resolved as quickly as possible. So he has moved to file a motion to expedite discovery. And so I'm going to go through these documents to kind of give you guys an update of exactly what Bishop T.D. Jakes is requesting. So let's hop right on into it. All right, so this is his the plaintiff. He's the plaintiff, Bishop T.D. Jakes' brief in support of the motion for expedited discovery. It says that his brief in support that is limited to two third-party subpoenas seeking solely documents. A subpoena to be served on an individual that commands production of documents over a narrow time frame, and B, related, a subpoena to be served on aforementioned individual's business that also commands production of documents over a narrow time frame. So if it's, I would say, let's say 30, 45 days to request these documents. That's the deadline. They're wanting to do it within 10 to 15 days. I don't know. I'm just throwing numbers out there. So he wants he wants to subpoena them. He wants whatever information or documents that he's asking for. He wants that immediately. It says plaintiff anticipates that these two third-party subpoenas would substantially reveal the identities of the John Does in this case, and thus enable this litigation to proceed more expeditiously and efficiently. For these reasons set forth below and in counsel's affidavit in support of the motion filed concurrently within, herewith the court should grant plaintiff motion for expedited discovery. Okay, well, if I would have kept reading, I would have known why they're asking to expedite this. So as you can see, the defendants is John Doe's 1 through 10. So they're wanting to get this information now so they can go ahead and continue with the litigation. As of now, the only facts that they have or names that they have is Dwayne Youngblood, but there were other people that was working with Youngblood to kind of extort Bishop T.D. Jakes. So they're wanting the names and the, whatever information, like within a 10-day or a 2-week period, not 30 days, not 45 days. They want it now. So, and it states right here what they're needing it for. Okay, they're saying that they want to reveal the identities of the John Does. Now, relevant factual and procedural background: on November 25th, 2024, plaintiff filed a complaint in this matter alleging that Dwayne Youngblood was liable for libel, and all defendants, including John Doe's 1 through 10, were liable for civil conspiracy to commit libel per se. Because y'all know that Dwayne Youngblood and other his co-conspirators have a history of extorting people for money, specifically pastors. Prior to uh, in prior to filing this proceeding, I don't know what's going on. On November 22, 2024, counsel for plaintiff contacted the attorney Tyrone, but you know what? I'm about to say Busby, Tyrone Blackburn. I don't know what Blackburn is doing, but mm. Anywho's, counsel for plaintiff contacted the attorney I keep saying Tony Busby, Tyrone Blackburn. Tyrone. We already know about Tyrone because Tyrone been doing some shady stuff. If anybody needs to be outed, it's Tyrone. Has delivered a letter labeled as appearance later, preservation notice, and offer of settlement, indicating that he represented Mr. Youngblood by telephone and left a voicemail to return the call. That call was never returned. Once the complaint was filed by email dated November 25th, counsel contacted attorney Blackburn to inquire whether he would accept service on behalf of his client. In response, we were unceremoniously told to proverbially pound sand and to serve Mr. Youngblood. By December 4th, 2024, efforts to serve Mr. Youngblood had been unsuccessful. Accordingly, in the email exchange dated December 4th, 2024, with attorney Blackburn, we inquired as to whether Mr. Blackburn had changed his position regarding waiver of service. Because normally what happens, you can't serve the individual. You are able to file a waiver of service if somebody accepts it on your behalf. And when I say somebody, your attorney, okay? Outside of that, can't nobody really, unless they do a motion to substitute service. So they contacted them and say, hey, we're trying to serve Mr. Youngblood. He's not available. Are you willing to accept service on his behalf? But they've been trying to get in contact with him, and from this, what I'm reading, and able to get in contact with attorney Blackburn. So in response, once again, attorney Blackburn refused to waive service, insisting that plaintiff serve Mr. Youngblood. Attorney Blackburn never stated whether he represented Mr. Youngblood for the purpose of this lawsuit. And if y'all wondering what Mr. Blackburn has done, he has actually worked with Dwayne in I think another case trying to extort somebody, but that's neither here nor there. Subsequently, plaintiff was able to effectuate service on defendant Youngblood, and on December 9th, 2024, the clerk of the court noted that the summons had been returned executed by the plaintiff and that defendant Youngblood was served late in the evening on December 4th, 2024. The defendant's Youngblood answer is due on December 26th. Okay, he filed the suit and they was having trouble. So dude served. So his answer is due the day after Christmas. And at this point, no attorney has filed a notice of appearance on behalf of defendant Youngblood. And Mr. Youngblood explicitly rejected an offer to accept more time to respond to the complaint. All right. So what they did is So the lawsuit was filed on what was that, November 25th. They were trying to serve him. They reached out to Blackburn because they were trying to get him served, and he wasn't accepting service, or he wasn't there. Who knows? So they called Attorney Blackburn. Blackburn ignored them, and he said, "Y'all need to just, go ahead and try to serve Youngblood." Youngblood was then served on the 4th of December. They filed the proof of service with the clerk of court on the 9th, and he has to respond to the lawsuit on the 26th. Now, if you say, "Oh my God, I have been sued," and you feel like you have to respond, okay? But if you feel like you need more time to respond to the lawsuit, you'll call the clerk of court and you would ask for some type of extension. And that is actually in the summons what you need to do. Okay. So it said he rejected the offer to accept more time to respond to the complaint. So it then says plaintiff submits that based on the exchange with Attorney Blackburn and the absence of any notice of appearance in this litigation on behalf of defendant Youngblood, reasonably speaking, we do not have opposing counsel with whom we can confer on the subject of this motion, and we do not anticipate defendant Youngblood to provide information at juncture that resolve the subject of this motion. So pretty much what that is saying is there is no attorney on file. Therefore, normally when you file a motion to it's certain motions that you have to confer or contact opposing counsel and come to some type of agreement. If you can't, then you just put that certificate of conference in your motion and you file it. So here they're just trying to say, hey, he doesn't have an attorney on file. We already had trouble trying to get him served. He hasn't responded. So, and we don't think that he will even provide this information. The only way and provide this information voluntarily. Okay, because remember what I told you guys. Discovery is the exchanging between parties information and production, certain documents. If you're not going to voluntarily do it, then the subpoena and you bypass the third party and you just go straight to, either the individuals or the entity that you're trying to subpoena. Given the criminal background of defendant Youngblood and on information and belief, the prior background of his co-conspirators, we submit that there is a very real danger that the information plaintiff to be identified seeks to identify and provide a proper factual articulation in an amended complaint will not be preserved long enough to be available through the normal discovery process. So they don't think that they'll ever get this information. And if they don't get this information, the only person that really suing at the moment is Dwayne Youngblood. And then also they want to be able to speed up the process because if you can get all of the names, then you can just file the amended complaint one time. Nobody wants there and find out a name here, amend the complaint, find out and there, and amend a complaint. You don't want to have 10 amended complaints. We just need to get everybody on board, amend a complaint accordingly, get them served, give them time to respond, and then you can continue on with the litigation. Here, plaintiff asserts a prima facie claim for conspiracy to commit defamation. Plaintiff alleges that defendant Youngblood acted with others to publish and broadcast the false claim that Bishop T.D. Jakes groomed him and actually assaulted or essayed Youngblood on a podcast reaching over 100K persons, knowing that making such false claims on a podcast that reaches such a broad audience listeners would harm Bishop Jakes. To wit, a person believed to be acting in concert with defendant Youngblood, that is the podcaster, identified in complaint as co-conspirator number one, falsely claimed in sum and substance that Bishop T.D. Jakes had engaged in settlement discussions with Youngblood regarding his claims, thereby trying to give a patina of veracity to defendant Youngblood's accusation. babies. So whoever that podcaster is, they about to be in this lawsuit. No such settlement discussions ever took place. The first podcast occurred on October 28, 2024, and in an effort to maximize their efforts, they launched a second broadcast on November 3rd, 2024, where they more clearly target the false claims of SA against Bishop Jakes by, in sum and substance, stating that Bishop Jakes trained defendant Youngblood and forcibly kissed him, as opposed to the first podcast where defendant Youngblood alleges that they embraced at the end of an hours-long, wide-ranging conversation about faith in life and parents. Plaintiff alleged that the primary motivation for these acts is money, because mind y'all, he has done it before, several times. The defendant demanded $6 million, or in effect, the podcast, two of which had already been produced, would continue. So it's saying, you give me $6 million now, or I'm gonna keep going on these podcasts, and I'm going to keep defaming you. A third podcast that aired mere hours after the complaint in this action was filed on November 25th, 2024. The podcaster admitted he had seen at least some portion of the $6 million extortion letter sent to plaintiff, and further admitted that he knew about the letter. Boy, Larry Reid, you about to get in trouble. Moreover, the podcaster states that he knew the letter was being emailed to Bishop Jakes. Okay, and let me go to this footnote. So it says the podcaster slyly, cunningly, and deceptively tries to avoid conceding that he read the letter by first stating that he does not know what the letter stated exactly. Zoom. Later in the podcaster alludes to the fact that maybe the letter contained a demand. Plaintiff submits that despite the attempts of equivation, equivocation. Okay. The podcaster was actually aware of the letter, its contents, discussed them with defendant Youngblood, and had done so before the letter was sent to Bishop Jakes, based on statements the podcaster himself makes. So you just implicated yourself, buddy. In another podcast, the podcaster concedes that he often pays interviewees to show on his show, and that to the extent they realize financial compensation for their quote unquote grievances, the podcaster expects to be compensated. Moreover, in the earlier, wait, hold up. The podcast, the podcaster. That's interesting. Moreover, in the earlier November 3rd, 2024 podcast, the podcaster admits that he has knowledge of money, sorry, that might be paid to defendant Youngblood as a result of his interviews. More particularly, during the November 3rd podcast, Youngblood is asked by a guest whether anyone has reached out to him to pay him off. The pastor imposes his own answer to the question by stating, in sum and substance, that he can't answer that question for sure, responding in the positive. At this point, plaintiff submits that we have a reasonable basis to believe the podcaster has knowledge of defendant Youngblood's money by making false statements against plaintiff, including knowledge about the $6 million extort letter sent to plaintiff, and B, financial compensation was provided to defendant Youngblood by the to participate in the podcast interviews where the false statements are launched. Further, on information and belief, plaintiff submits that there was a plan between and among defendant Youngblood and his co-conspirators, including the podcaster, to share in the anticipated extortion payment once made. Moreover, the podcaster was able to realize other channels of financial gain by launching the series of podcasts related to defendant Youngblood's false statements against plaintiff. The November 25th, 2024 podcast alone, by the podcaster's own admission on the live show, attracted 5,607 viewers to the YouTube show. At the end of the show, the podcaster requested that those 5,607 persons make a donation to his show if they enjoyed the update. A banner appeared on the screen advertising such donations could be made through a wide number of mechanisms, including PayPal, Venmo, and Zelle. The identity of John Doe's is essential to efficiently advancing this matter. Without the requested early discovery described herein, plaintiff submits that he will unreasonably delay in amending the complaint to include other culpable parties, b risk iterative conferences with the court once those parties are later added during traditional formal discovery, and C suffers burden along with the other litigants of potentially avoidable disjointed motions initiating challenging the complaint, which in turn will likely disrupt the orderly flow of the case management plan in this case. And I do agree, because at the y'all know the petitioner bears the burden of proof, but how can you sit there and saying when you have all these John Does? You have to be able to, one, name the John Does, and then amend the complaint, get them served, give them time to respond, and then you continue with the case. So they're trying to say that he is going to suffer if he's not. And when I say suffer, as meaning like this case is just going to sit and be, subject to be dismissed if they cannot find those other defendants. They need to be named so the complaint can be amended. Here, the plaintiff knows the identity of the podcaster. However, Bishop Jakes requires Expedite Discovery to further develop the factual matter to the properly and appropriately support naming the podcaster and the podcast company as named defendants in this case in accordance to the federal rules. Plaintiff anticipates that the requested information in connection with these two subpoenas will also reveal the identity of John Doe's, whom will also be named as a result of the expedited discovery. Baby, let me tell you, Larry Reid and his company about to be included in this lawsuit, baby. Boy, this is tea right here. This is tea right here. Statements of question involved. So, and y'all see that, right? So where'd it go? So he knows the identity of the podcaster, but he wants to properly and appropriately support naming the podcast and the podcaster and the company. So you can't just say Larry Reid, okay? If he actually filed the business or his company, you have to have the proper name of him as well as his company to include. Okay, because you don't want to have to sit there and amend the complaint if you got the name wrong, because they can easily file a motion to dismiss because the name is incorrect. Statement of questions involved in consideration of the administration of justice and the possible prejudice or hardship to the defendant. Does good cause exist justifying expedited discovery? By the proposed answer is yes. Legal standards. Plaintiff acknowledges that generally the federal rules of civil procedure do not permit formal discovery before the required Rule 6F scheduling conference occurs. So that means, okay, so they have to have a scheduling conference and then they can do discovery. However, courts may permit expedited discovery before the Rule 26 conference upon showing a good cause. Good cause may be found where the need for expedited discovery in consideration of the administration of justice outweighs the prejudice. Courts routinely allow early discovery where it will substantially contribute to moving the case forward and is narrowly tailored for that purpose. Among other factors, consider whether a preliminary injunction is pending, 2, the breadth of the discovery request, 3, the purpose of requesting the expedited discovery for the burden on the defendant of compliance with the requested discovery, and 5, how far in advance of the typical discovery process the request will be made. And so I'm reading all that. Let me just get all this. Good cause exists in this instance. All right. So they need those 2 subpoenas to subpoena the podcaster and his company to get the information that they need. Because why do they think that? Because Larry Reid made a comment, or he was speaking about seeing the extortion that was sent to Bishop T.D. Jakes before. If I let me make sure I got that right. Yep, he said there was a plan between and among defendant Youngblood, his co-conspirators, including the podcaster. Mm-hmm. Mm-hmm. Yep. He had seen at least some portion of the $6 million dollar extortion letter sent to plaintiff. Yep. Bro, in the words of my kids, bro is cooked. All right, getting down to the argument. So they saying it's a good cause. As a threshold matter, plaintiff deserves a prompt adjudication of his claims against the defendants, which merely necessarily begins with an ability to identify the persons involved with defendant Youngblood in his efforts to systematically defame Bishop Jakes in exchange for a payoff and other related financial gains. Plaintiff has already developed some information that would support factual articulation of at least one co-conspirator, but requires additional specific information that would support operation of the conspiracy claim, including the mechanics of the conspiratorial conduct, thus bringing light an even clearer picture of the behavior at issue in this case and the persons involved. This particular need directly supports the administration of justice in this case. Defendant Youngblood is not prejudiced by this expedited discovery, and it does not impose any hardship on him, meaning that he's not going to be harmed in any way. It's not going to cause him to have a litigation case or nothing of that matter. This application does not deprive defendant Youngblood of opportunity to object to the intended Rule 45 subpoenas, because naturally he is able to articulate any opposition by responding to this motion. Moreover, the returns from the Rule 45 subpoenas would be made available to in the normal course and as required by the federal rules of civil procedure. So pretty much whatever is obtained from the subpoenas and given to Jakes and his attorneys, that information will then be also turned over to Youngblood. And if he had an attorney, then he would also get a copy of that. But as of right now, he doesn't have an attorney. He hasn't responded. So all information would go to Dwayne, and he have to forward it to an attorney if he decides to get an attorney later on. So even if defendant Youngblood is pro se, that means self-represented in this action, the application does not request any material from him where he might otherwise be prejudiced in the absence of an attorney. The requests under the anticipated subpoenas are narrowly tailored. First, in the terms of the Rule 45 subpoena directed to the broadcaster, and we're going to see Declaration A in a minute, the request can be grouped analytically in the following matter. So in request 1 through 3, it's intended to establish actual identification, which is critical for properly identifying the putative defendant. Request 4 through 5 is a probative of the relationship and interactions between the probative defendant and defendant Blackburn. Ooh, baby. Over an approximately 3-month time frame encompassing a period slightly before the first podcast and then the period during 2 of the 2 podcasts. It says putative defendant and defendant Blackburn, Tyrone is included in the lawsuit. I, it, is he included in the lawsuit or is this a typo? Request 6 through 8, information that likely elaborate upon statements already made by the podcaster, including his knowledge about November 15th extortion and his interaction with attorney Blackburn prior to the letter being sent to the plaintiff. Request 9, data and material that would augment plaintiff's current understanding about the putative defendant's financial motivation to act in furtherance of and in accordance with defendant Youngblood's false allegations against Bishop Jakes. Fundamentally, none of requests 1 through 3 can reasonably pose a burden to the putative defendant. Proving your actual legal name and address is something most persons engage with every day across contexts. With respect to the remaining requests, the putative opened the proverbial door on the inquiries at minimum by and through his November 25th podcast, Baby, Talk About Reid, that took place specifically in response to the filing of the lawsuit. Again, during the past, the putative defendant described having knowledge of the extortion letter B, admitting to having seen at least some aspect of the letter C, and strongly alluding to knowing what the extortion letter stated before it was sent to plaintiff. Most third parties object to Rule 45 subpoenas because they do not want to be bothered with litigation that does not involve them. However, here, the putative defendant specifically, intentionally, and deliberately interposed himself in the lawsuit by his own provocate, oh my gosh, pro, provocative statements that raise substantive. Clown me, y'all. It's been a long day. Statements that raise substantive questions about his role in related legal liability as a participant in the conspiracy, all on a public broadcast and in full face of and with an understanding that the lawsuit has been filed. So what they are saying is like I said before, they are subpoenaing Larry Reid and his company, because if they're going to go after another person, since they believe that Dwayne Youngblood, he hasn't responded to the lawsuit. So if he ain't responded yet, they don't believe that, they could send a letter say, hey, name the rest of the defendants. He don't think that they're going to give him that information, in which I know he's not. So you need to go after another person that possibly has this information. And instead of them instead of Jake's attorneys reaching out to Larry Reid and saying, hey, provide us with the information. Like, if you know the names, give us the names. They're going to subpoena it. A subpoena holds weight. You don't provide this information by a certain date, you can be held in contempt. So, the second rule, 45 subpoena on the company, is in similar scope. So one subpoena going to Larry Reid, the other one going to his company. Ah, be gosh darn it. The time frame for the requested information are narrow. The requests largely mimic those in the first Rule 45 subpoena and are intended to avoid the situation where the podcaster claims not to have the documents such as emails or texts that are otherwise maintained on the corporate devices or systems. So that's why they are trying to get this information in these documents, because what happens is he can't if he gets the subpoena and the subpoena gives him 30-45 days to produce this information, that's enough time for him to do something for it. Okay. However, if they say you got 10 days, then chop chop. You got to get it on. Because if you don't, by that certain date and time, then you're in trouble. We submit the reasons for the subpoenas described above on balance favor the court granting the motion and permitting expedited discovery as described herein. Again, the scope of anticipated discovery is narrow. The purpose is clear. Effectuate a process through which the co-conspirators in the matter can be clearly identified and the complaint can be expeditiously amended so as to include those defendants along with a proper and a appropriate description of their role in that conspiracy. And this was submitted 2 days ago. Ooh, wait. Now the other documents. So wait, let me see. Where is A? How did my? Oh, that's A. So this is the subpoena. Let's look at what they're asking for. Documents sufficient to identify your true name, identify your current permanent email address, all documents and communications relating to Dwayne Youngblood from August 1st, 2024 to November 25th, 2024. Any documents and communication referring or relating transfer of any monies to Youngblood from August 1st to November 25th, 2024. Any documents, all, not any and all documents of communication with attorney Tyrone Blackburn, including but not limited to the settlement discussions referred to you in the October 28th Larry Reid live episode, such and such. And you can't take this YouTube thing down because guess what? They subpoena YouTube, you in trouble. All documents and communication with Tyrone. Boy, Blackburn, you just y'all, they're not even playing. Documents sufficient to show the ownership structure of Larry Reid Live. They want because he had different avenues to receive donations. So they want to know dude's PayPal, his Cash App, his Venmo accounts. And not all. So it says including but not limited to. So if you have any other avenues where people are able to make donations or payments, you need to cough those up. Mm, baby. Mm-mm. This is the declaration. Um, Prior to in this proceeding, November 22nd, 2024, the undersigned contacted Blackburn to deliver. All right. So this was all right. So it's just a declaration to support why they are needing um a motion to expedite discovery. So they have the proposed draft of the subpoena to address the podcast Larry Reid, the subpoena to address the podcaster's company, Larry Reid LLC. They are requesting the interviews that he did on 10/28, 11/25, and 11/3. Yeah. Let me see what the rest of these are. These are just subpoenas. These are the same thing. Oh, ooh. Oh, we might have to do, Lord, hold up. Hold up. All right. So these are the video recordings. Oh my gosh. I know. Boy, US Legal is making money. I'm just going to tell y'all that they is making money. Shout out to Sarah. So she had to sit here and my sister tried to get me to do this. I said, girl, I'm already a paralegal. I don't want to sit there and be transcribing phone calls and video. I don't want to do it. Girl, good luck with you. And here's the certificate of the transcriptionist. Okay. So ain't nothing coming in. She's not adding her 2 cents. She is simply watching the video and transcribing it. So this is the transcription of the YouTube videos. And this is the October 28th. This is the November 24th, November 25th. And I'm not going through that because y'all saw one was 132 pages, one was 82 pages. Y'all, well, I don't know if y'all like him, but I mean, if y'all want to go be nosy, go watch those videos. And that one's 41 pages. So this is the motion. So it not the motion, I'm sorry, the proposed order to the motion. So normally a motion has to be scheduled for a hearing. If the judge grants it, then he will sign this proposed order granting plaintiff's motion to expedite. And if that is the case, then they can go ahead and issue out those subpoenas to Larry Reid and his company. Who baby. And then let me see. They ended up filing a supplemental declaration. And they also are including Exhibit F, which is the 11.3 video. Okay, so that's what they're trying to make sure that they have to the transcription of the 11.3 part 2 video of that. So I I'm speechless because I honestly did not think that I to be honest, when I saw the motion to expedite discovery, I honestly was not thinking about the not the other, but the John Does of the case. It makes sense now. So, what they're wanting to do, and this is the summary, what they're wanting to do, Bishop T.D. Jakes and the lawyers, they want to expedite the discovery. So they have filed a motion with the court to request that discovery be expedited. The reasons for this is so that the case can move along. Dwayne has already been served. His response is due on the 26th. As of right now, no answer has been filed with the court. They were under the impression that attorney Tyrone Blackburn was his attorney, and he was not. He's pretty much say, y'all need to go ahead and, and this is before Dwayne was served. He's just saying, y'all need to do y'all due diligence and try to get this man served, in which they did. But the fact that attorney Tyrone Blackburn has had yet another connection um with someone that, and I don't want to say someone that, the fact that he has a connection with Dwayne Youngblood, and I've read that. Go back and watch that video, and when they said Tyrone Blackburn, I said, what? So now you have a connection. And then now Bishop T.D. Jakes is saying, or the attorneys rather, that Dwayne hasn't answered. Tyrone is not his attorney. Therefore, we need to get this information. We need to find out who the co-conspirators are. The best way to do that is to go to the person who said that he has seen the extortion letter, and he's had conversations with attorney Tyrone Blackburn. So instead of saying, I'm going to call him up and I'm going to get this information, they said, no, we need to subpoena Larry Reid. We need to subpoena Larry Reid's company so we can obtain all the information, all of the emails, all of the call logs, everything from his company. And he needs to preserve that evidence. One, if you don't preserve that evidence, you're in trouble. Two, if you don't provide that information and production at a certain date and time, as included on that subpoena, you're going to be held in contempt and whatever else. I don't know what they do in Pennsylvania, but I know if you don't not listen, if you don't follow a subpoena, that's consequences there. So this motion has only been filed. It hasn't been scheduled for a hearing. I am going to keep up with this docket. I don't know if any other content creators are talking about this, but if they are, I'm pretty sure Larry Reid already knows that he's in hot doo-doo. Larry Reid, Attorney Blackburn are in trouble. And this is another juicy case that we all need to stay on top on. Y'all tell me what y'all think about it in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed, and I'm out. Bye.